Step away from the vehicle. Now, hands where I can see them.
Officer, this is my car. I have the key in my hand. What crime do you believe I've committed?
You're being uncooperative.
That's enough.
Turn around.
You're detaining me without reasonable suspicion. If you cuff me, this becomes a federal case.
We'll see.
The parking lot security camera captured everything, every word, every movement. And Officer Kyle Miller had absolutely no idea that the man he was about to handcuff had spent the last 22 years sitting on the federal bench, presiding over cases involving police misconduct, civil rights violations, and Fourth Amendment abuses. Standing next to my black BMW 7 Series, I wasn't panicking. I wasn't shouting. I wasn't begging. My name is Judge Marcus Thorne, and I have sentenced corrupt police officers to prison. I have ruled on qualified immunity cases. I have written legal opinions that became binding precedent across the 11th Circuit. And in that moment, I knew I was about to become the plaintiff in a lawsuit that would cost the city hundreds of thousands of dollars and end multiple careers. Before I tell you the rest of this absolutely shocking story, I need you to do something. Leave a comment right now and tell me where you're reading this from. Your country, your state, wherever you are. And if you believe in holding authority figures accountable when they abuse their power, pay close attention. This story gets even more intense. You don't want to miss what happens next. I am not someone who expects special treatment. At 55 years old, I have been a federal judge for over 2 decades. I have handled RICO cases, capital punishment trials, and complex civil rights litigation. I have always been fair, thorough, and known for holding both prosecutors and defense attorneys to the highest standards. That Saturday afternoon, I had been shopping. Nothing unusual, nothing suspicious, just a regular weekend errand run. I had gone to a high-end outdoor mall in Buckhead, Atlanta, purchased some items for my home, and was loading shopping bags into the trunk of my BMW when everything went wrong. The car was mine, properly registered with current Georgia tags. I had the key fob in my hand. I was dressed in casual weekend clothes, slacks, and a polo shirt. Nothing flashy. I was doing exactly what thousands of people do every day in parking lots across America, loading purchases into a vehicle and preparing to leave. Then I heard the voice behind me. "Sir, step away from the vehicle." I turned around. An Atlanta police officer was approaching me, hand on his service weapon, not drawn, but resting on it. A position of readiness. Officer Kyle Miller was 29 years old, with 6 years on the force, and was responding to what he thought was a suspicious person call. Someone had reported a man acting suspiciously near expensive vehicles in the parking lot. The description was vague. Black male, heavy build, near a black BMW. That was it. No description of suspicious behavior, no report of attempted theft. Just a black man near an expensive car. Miller had decided that I was the suspicious person. I kept my hands visible, one still holding my key fob. "Is there a problem, officer? I need you to step away from the vehicle and show me some identification." My legal mind immediately recognized what was happening. This was a Fourth Amendment seizure. Miller had detained me without reasonable suspicion of criminal activity. I had 2 choices: comply and sort it out later, or assert my rights immediately. I chose assertion. "Officer, I'm loading my own car with my own purchases. I have the key fob right here. What reasonable suspicion do you have that I'm engaged in criminal activity?" Miller didn't like the question. Most people he stopped didn't ask questions. They just complied. "Sir, I'm investigating a suspicious person report. I need to see your ID." "What specific suspicious behavior was reported?" I asked calmly. "Because loading shopping bags into a car isn't suspicious. It's normal." Someone called in a report. A report of what specifically? What crime do they believe was being committed? Miller's hand tightened on his weapon. "Sir, you need to cooperate. I am cooperating. I'm asking you to articulate the legal basis for this stop. That's not obstruction. That's my constitutional right. The confrontation was escalating. Other shoppers were starting to notice. Some slowed down to watch. One young man pulled out his phone and started recording from about 20 feet away. I'm not going to ask again, Miller said. Step away from the vehicle and provide identification. I made a decision. I would comply under protest, document everything, and handle this through the proper legal channels. I had been a judge long enough to know that arguing with police in parking lots was dangerous, especially for black men in America. Officer, I'm going to comply with your request, but I want to state clearly that this stop lacks reasonable suspicion and violates my Fourth Amendment rights. I'm reaching for my wallet now to retrieve my identification. I moved slowly, deliberately. My hands stayed visible. I reached into my back pocket and pulled out my wallet. Inside was my driver's license, my federal judge identification, my courthouse security credentials, and my Georgia bar card. I handed Miller my driver's license first. He looked at it. Marcus Thorne. The address matched the vehicle registration he could see through the windshield. "This your car?" he asked. "Yes, prove it, sir." I held up the key fob and pressed the lock button. The car's lights flashed, and the horn chirped. I pressed unlock. The lights flashed again. Satisfied, I asked. Miller should have apologized and left. He had detained someone loading their own vehicle with their own belongings. There was no crime, no violation, no reasonable suspicion. But Miller had a problem. He had made this stop in front of witnesses. He had escalated the confrontation. And backing down now would look like weakness, so he doubled down. "You're being belligerent and uncooperative. I'm going to need you to wait here while I verify this information." Have you ever been detained by police for doing absolutely nothing wrong? Think about that for a second. I felt my anger rising, but I kept it controlled. "Officer, I've provided identification. I've demonstrated ownership of the vehicle. There's no legal basis to continue this detention. Am I free to go?" "No, you need to wait while I run your information." "On what grounds?" "On the grounds that I'm conducting an investigation." "An investigation into what crime?" Miller didn't answer. He walked back to his patrol car with my license. I stood next to my BMW, hands visible, waiting. I looked at the young man who was recording and gave a small nod. "Keep recording," the nod said. "This matters." Miller sat in his patrol car, running my license through the system. It came back clean. No warrants, no criminal history, perfect driving record. The registered owner of the vehicle matched the license. Everything checked out. Miller should have returned. The license apologized for the confusion and let me go. But he had a bigger problem now. He had made a bad stop and continued it past the point of reasonableness. He needed to find something to justify his actions. He got out of his patrol car and approached me again. "Sir, I'm going to need to search your vehicle." My eyes narrowed. "On what basis?" "I have reasonable suspicion that there may be stolen merchandise in the vehicle, based on what I have receipts for everything I purchased. The bags are from stores in this mall." "Your reasonable suspicion is based on what specific articulable facts?" Miller was trapped. He had no facts. He had a vague suspicious person report and his own assumptions. That's not reasonable suspicion. That's not probable cause. That's bias. "Sir, you're being uncooperative. That gives me reasonable suspicion." I almost laughed. "No, officer, it doesn't. Asserting my constitutional rights is not evidence of criminal activity. Arizona versus Johnson establishes that clearly. You cannot use my refusal to consent to a search as justification for reasonable suspicion." Miller's face flushed. "Are you a lawyer?" "I'm a federal judge." The parking lot seemed to go quiet. Even the background noise of traffic and shoppers seemed to fade for a moment. Miller stared at me. You're a what? A federal judge, United States District Court, Northern District of Georgia. I've been on the bench for 22 years, and you've just violated my Fourth Amendment rights in a way that is so clearly established that you won't be able to claim qualified immunity. Miller's hand moved away from his weapon. His posture changed for the first time since the encounter began. Uncertainty crossed his face. I need to see proof of that. I reached back into my wallet and pulled out my federal credentials, the official United States Court's identification with my photograph, my name, my title, and the seal of the federal judiciary. Miller took the credentials and studied them. His hands were shaking slightly. This could be fake, he said, but his voice had lost its authority. Call the federal courthouse. The main number is public. Ask for Chambers. They'll confirm my identity. The young man who had been recording spoke up from his position 20 feet away. I've got all of this on video, he called out. Everything. Miller looked at him, then back at me. Sir, I'm going to need you to step away from the vehicle. We're past that point, officer, I said calmly. You've already detained me unlawfully. You've continued the detention past any reasonable time frame. You've requested a search without probable cause, and now you're escalating because you've realized you made a mistake. What you should do right now is return my identification, apologize, and call your supervisor. I don't have to do anything. Actually, you do, because I'm not just going to file a complaint. I'm going to file a federal lawsuit, and every decision you make in the next 60 seconds is going to be evidence in that lawsuit. Miller made his worst decision of the day. Instead of de-escalating, instead of calling a supervisor, instead of admitting the mistake and trying to minimize the damage, he decided to assert his authority. Sir, turn around and place your hands behind your back. You're under arrest for what? Interfering with a police investigation. There is no investigation. There's an officer who saw a black man in an expensive car and made assumptions. But if you're going to arrest me, do it. The video is rolling. My credentials are in your hand, and you're about to make the biggest mistake of your career. Do you think the officer should have just apologized and walked away at this point? Miller pulled out his handcuffs. I turned around slowly. I placed my hands behind my back. The metal cuffs clicked around my wrists. The man recording the incident was talking on his phone now, presumably calling someone. Other shoppers had stopped to watch. A small crowd was forming. What's happening? Someone asked. The police are arresting a federal judge for loading groceries into his own car, another person answered. Miller walked me to his patrol car. I didn't resist. I didn't argue. I just walked calmly, my head held high, my expression unreadable. He placed me in the back seat of the patrol car. The plastic seat was hard and uncomfortable. The car smelled like stale coffee and the chemical cleaner they used on the seats. I sat perfectly still. My mind was already working through the legal strategy. What claims to file, what evidence to preserve, what witnesses to contact. Miller got in the front seat and sat there for a moment. He picked up his radio, then put it down. Picked it up again, put it down again. He knew he had made a mistake, a catastrophic mistake, but he had committed to the arrest. There was no way to undo it now without looking incompetent. He started the car and drove to the police station. The drive took 11 minutes. He didn't say a word. Neither did I. When we arrived at the station, Miller brought me inside. Other officers looked up from their work. They saw a well-dressed black man in handcuffs and didn't think much of it initially. Miller took me to the processing area. A female officer named Sarah Jenkins was assigned to process me. Jenkins was a 15-year veteran who had seen everything. Jenkins started the standard booking procedure. Personal belongings, removed and catalogued phone keys, wallet, watch. When Jenkins opened the wallet, She saw the federal judge credentials immediately. She looked at the ID card, looked at me, looked at Miller. "Where did you arrest him?" Jenkins asked quietly. "Parking lot of the mall in Buckhead." What was he doing? Loading shopping bags into his car. Jenkins's expression didn't change, but her eyes went hard. What were the charges? Interfering with an investigation. What investigation? Suspicious person report. Jenkins held up the federal credentials. "Did you verify these? I think they might be fake." Jenkins had processed thousands of arrests. She had seen every kind of fake credential that criminals could produce. These weren't fake. The holographic seal, the microprinting, the weight and texture, these were real federal court credentials. She stepped away from the processing desk and walked directly to her watch commander's office. Lieutenant James Henderson had been with the Atlanta Police Department for 25 years. He had handled difficult situations. He had managed controversial arrests. But when Jenkins walked into his office holding federal judge credentials, his stomach dropped. "Where's the person these belong to?" Henderson asked. "Processing area." Miller brought him in, arrested him for interfering with an investigation. Henderson stood up immediately. He walked to the processing area and looked at me, sitting calmly in the holding chair. He looked at the credentials again. He walked to his office, closed the door, and made a phone call. The call went to the duty assistant chief. The conversation lasted 3 minutes. When Henderson hung up, he looked like he had aged 5 years. He walked back to the processing area. "Judge Thorne, I'm Lieutenant Henderson. I apologize for this situation. You're being released immediately." "What was I being charged with?" I asked. "That's being reviewed. I want everything in writing. The initial call, report, the body camera footage, the dash cam footage, the booking report, Officer Miller's written statement of probable cause, everything." Henderson nodded. "We'll have those ready for you." "How long will that take?" "We can have digital copies ready within 24 hours. I want them tonight." There was no room for negotiation in my voice. Henderson recognized the tone. He had heard it in court before. The tone of a judge who had made a ruling and expected compliance. "I'll make sure you have them tonight." I was uncuffed. My belongings were returned. I was escorted out of the station by Lieutenant Henderson himself, who apologized 3 more times before I got in the Uber I had called. I arrived home at 6:47 in the evening. I had been detained for 2 hours and 33 minutes. I sat in my living room for a long moment processing what had happened. Then I picked up my phone and started making calls. The first call went to the Chief Judge of the Northern District of Georgia. The second call went to my longtime friend who practiced civil rights law. The third call went to the ACLU. By Monday morning, the incident was being discussed at the highest levels of both the federal court system and the Atlanta Police Department. The chief of police personally called me to apologize. I listened politely and said I would be filing a federal lawsuit regardless. The lawsuit was filed on Wednesday. 23 pages, single-spaced, with citations to Supreme Court cases and references to specific timestamps in the video footage and body camera recordings. The lawsuit alleged unlawful detention, unlawful arrest violation of Fourth Amendment rights, violation of 14th Amendment, equal protection rights, and racial profiling. It named Officer Kyle Miller individually and the City of Atlanta. The city attorney's office reviewed the case. They watched the parking lot security footage. They watched the body camera footage. They read the lawsuit. Then they called an emergency meeting with the police chief and the city manager. "This is indefensible," the city attorney said bluntly. "We detained a federal judge for loading his own car. The video shows it clearly. We have no legal defense. We need to settle." But before settlement negotiations could begin, the story leaked to the media. Local news picked it up first, then national outlets, then legal publications. "Federal judge arrested while shopping" became a headline that spread across the country. The video from the man in the parking lot was posted online. Within 24 hours, it had 3 million views. Within a week, it had been viewed over 15 million times. The comment sections exploded. People shared their own stories of being profiled. Legal experts broke down every violation Miller had committed. Civil rights organizations used it as evidence of systemic problems in policing. The Atlanta Police Department opened an internal investigation. They assigned their most senior internal affairs investigator to the case. The investigation took 4 weeks. They interviewed Miller multiple times. They reviewed every second of available footage. They analyzed the suspicious person call that had initiated everything. The findings were damning. The suspicious person call had been made by a mall security guard who had later admitted he thought I looked out of place near expensive cars. When pressed on what that meant, he couldn't articulate any specific suspicious behavior, just a feeling. Miller had responded to that vague call and immediately focused on me based on race. He had detained me without reasonable suspicion. He had continued the detention past any reasonable time frame. He had requested a search without probable cause. He had arrested me for asserting my constitutional rights. Every single action he took was a violation of department policy and constitutional law. The investigation also found patterns in Miller's history. Over the previous 3 years, Miller had made stops involving black motorists at a rate 2.8 times higher than the department average. His searches of black motorists were 3.4 times higher. His arrest rates showed similar disparities. The pattern had been there for years. Nobody had looked at the data. Nobody had connected the dots. Officer Kyle Miller was terminated 6 weeks after the incident. The termination letter cited multiple violations: unlawful detention, unlawful arrest, racial profiling, violation of department policy and conduct, and becoming an officer. Miller tried to appeal. His union representative reviewed the footage and told him the same thing everyone else was telling him: "You're finished. The video is too clear. The victim is too credible. The violations are too obvious." Miller withdrew his appeal, but his termination was just the beginning of the consequences. The Department of Justice Civil Rights Division opened an investigation into the Atlanta Police Department's stop and search practices. They wanted to know if Miller's bias was isolated or symptomatic of larger problems. The investigation took 8 months. They analyzed 5 years of stop data. They reviewed thousands of police reports. They interviewed dozens of officers and community members. Their findings were released in a 97-page report. Black residents were stopped at rates significantly higher than white residents, even after controlling for crime rates and population. Black motorists were searched at rates 3 times higher, despite being less likely to be found with contraband. The Atlanta Police Department entered into a consent decree with the Department of Justice. The reforms were comprehensive, mandatory, implicit bias training for all officers, an early warning system for officers with problematic patterns, a civilian oversight board with real authority, regular audits of stop data by race body camera, requirements for all uniformed officers, and federal monitoring for 3 years. My lawsuit settled 9 months after the incident. The settlement amount was never publicly disclosed, but sources familiar with the negotiations said it was $750,000. I donated the entire settlement to civil rights organizations working on police reform. I don't need the money. I need the system to change. I need other people who don't have my resources and position to be protected from what happened to me. The parking lot security footage became required viewing at police academies across Georgia. It was used in constitutional law classes. Civil rights organizations used it in community education sessions. One 2-hour detention in a parking lot led to a terminated career, a $750,000 settlement, a federal consent decree, and systemic reforms that affected how an entire police department operated. Kyle Miller never worked in law enforcement again. His termination for cause made him unhireable to other agencies. He tried private security work but couldn't maintain employment. He eventually left Georgia entirely. I returned to the bench. I continued presiding over cases, including several involving police misconduct. Colleagues said the experience made me even more attuned to civil rights issues in my courtroom. In private conversations with other judges, I have said that what happened to me wasn't unique. It was just documented. Thousands of Black Americans experience similar treatment every day, but they don't have federal credentials. They don't have legal knowledge, and they don't have the resources to fight back. That's why I pushed for the footage to be made public and why I donated the settlement, so the incident could become a teaching moment, so people could see what racial profiling looks like, so officers could learn that assumptions aren't evidence and bias isn't reasonable suspicion. The security camera's footage is still online. You can watch it yourself. You can see a federal judge calmly asserting his rights while being detained for the crime of shopping while Black. You can see the moment Miller realizes what he's done. You can see what accountability looks like when the system actually works. What's your biggest takeaway from my story? Leave it in the comments below. And if this opened your eyes to the reality of racial profiling, share this story. My story matters because I had every advantage. I had legal knowledge, I had credentials, I had position and authority, and I still got handcuffed in a parking lot for loading shopping bags into my own car. Think about everyone who doesn't have those advantages. Everyone who gets stopped and searched based on assumptions. Everyone who gets arrested for asserting their rights. Everyone who doesn't have the knowledge or resources to fight back. My story shows that even when you have every advantage, bias can still affect you. But it also shows that accountability is possible, that the system can work, and that consequences can follow violations. Not every unlawful detention ends with justice. Not every case of racial profiling leads to termination and reform. But this one did, and that matters. Thanks for listening to my story all the way through. If this made you think differently about police accountability and racial profiling, share it with someone who needs to see it. We need to keep telling stories that matter. Important educational note. This story is a dramatization based on true events involving Judge Kisha Langford. While the names, ages, locations, and specific details have been changed, portraying the protagonist as a male judge in Atlanta named Marcus Thorne, the legal principles regarding the Fourth Amendment, reasonable suspicion, and the reality of racial profiling remain factually grounded. The purpose of this narrative is to educate the public on their constitutional rights during police encounters and to highlight the systemic issues regarding bias in law enforcement. It serves as a reminder that legal knowledge is a powerful tool, but systemic reform is necessary to protect all citizens equally.